Good afternoon, everybody, all the attendees of the webinar, the United Ulamaa Council of South Africa, UUCSA position on the Women's Legal Center Trust judgment and how it applies to Section 7.3 of the Divorce Act. My name is Munir Abdul Rauf. I'm an associate professor at the University of the Western Cape, Faculty of Law. And I'm one of the facilitators that will be presenting or basically be facilitating the webinar this afternoon in conjunction with Professor Najma Musa and Dr. Ashraf Buli and Mr. Muhammad Hussein Sangay. All right. This webinar is a maiden webinar of a newly established unit, which basically falls under the CLIA. It is basically the Center for Legal Integration in Africa, and that is part of the University of the Western Cape Faculty of Law. Right. And this is the first webinar for 2024 and also the first webinar in the newly established unit. The presenter this afternoon is none other than Attorney Ismail Muhammad. He is a member and representative of the United Ulamaa Council of South Africa, the legal advisor there, as well as a member of the Muslim Judicial Council legal desk. A brief background of Attorney Ismail Muhammad. He basically studied Arabic and Islamic studies in Newcastle in KwaZulu-Natal. Thereafter, he completed an alim course at the International College of South Africa. He then also completed an LLB law degree here at University of the Western Cape. So he is an alumnus of this university and a faculty where he's actually giving the talk or the webinar. And he's also a practicing attorney of the High Court of the Republic of South Africa, right? And his presentation this afternoon is a very interesting one. We all know of Muslim marriages in South Africa, and this Women's Legal Center Trust judgment has, or this matter has appeared before the High Court here in the Western Cape. It has gone to the Supreme Court of Appeal and finally ended up at the Constitutional Court. And Attorney Ismail Muhammad will be discussing that judgment and more specifically how it applies to Section 7.3 of the Divorce Act. So without any further ado, right, I will hand over to Attorney Ismail Muhammad. But before that, there's only a few house rules. Please note that all mics and videos should be off during this time period as to avoid any issues concerning connectivity. Any questions that you may have, you can basically put it in the chat group, and Mr. Muhammad Hussein Sangay will basically be dealing with those questions. And yeah, without any further ado, I hand over to the presenter. You may begin.
Assalamu alaikum wa rahmatullahi wa barakatuh. Shukran, Sheikh Munir. Good afternoon to everyone. I was asked to speak about the position of the United Ulamaa Council of South Africa towards the Women's Legal Center judgment and how it impacts on the judgment given by the Constitutional Court in October 2023 when it extended the application of Section 7.3 of the Divorce Act. I'm not going to go into too much detail on the second case, and it will become clearer later. In order to understand UUCSA's position, it is necessary that I provide some background. The United Ulamaa Council of South Africa started in 1994. It comprises of 9 ulama institutions from all around South Africa. One of its main objectives when it started was to persuade and assist the government to develop legislation to recognize Muslim marriages. At the dawn of the new South Africa, a couple could only marry under the Marriage Act. Currently, there are two further acts, the Recognition of Customary Marriages Act and the Civil Union Act. Not a single one of these pieces of legislation recognize Muslim marriages. UUCSA believes that Muslims are entitled to legislation codifying Islamic marriage and divorce law for the following reasons. In Islam, a marriage is a covenant between two people, a man and a woman. While this contract may be with each other, at the same time, the parties make a covenant with God, the creator of the heavens and the earth. The parties declare to God that they are marrying on the instruction of God, in the obedience of God, for the pleasure of God, and in the presence of God. They declare further that they will be good to each other for the sake of God, and that they will stay together for the pleasure of God. In addition, in Islam, the couple marries under Islamic law. Islamic law is revealed law, prescribed by God. God is the lawmaker. A Muslim owes fidelity to God and to God's law. The heart and soul, the very conscience of every Muslim is bound by the law of God. This consciousness towards God and God's law forms part of the very being of every Muslim. Muslims exist only for God. Every act on this earth is for God alone. A good act towards a spouse in this earthly realm may have positive earthly effects. However, the real purpose is to attain God's pleasure. The Constitution of South Africa protects and guarantees every person's right and freedom to practice his or her religion without hindrance. Section 15(1) of the Constitution guarantees everyone, including Muslims, the right to freedom of religion. The Constitutional Court in S versus Lawrence defined the essence of the concept of freedom of religion as follows. The court said, the right to entertain such religious beliefs as a person chooses, the right to declare religious beliefs openly and without fear of hindrance or reprisal, and the right to manifest religious belief by worship and practice, or by teaching and dissemination. Section 15, therefore, does not only guarantee the right to have a belief, but includes the right to practice this belief. This section, therefore, guarantees for Muslims the right to believe in Islam and to practice their faith, and in this particular context, to marry and divorce under Islamic law. In the Lawrence case, Judge Chaskelson went further and said, freedom of religion means more than this. In particular, the judge stressed that freedom implies an absence of coercion or constraint, and that freedom of religion may be impaired by measures that force people to act or refrain from acting in a manner contrary to their religious beliefs. This interpretation of the constitutional guarantee by the highest court in the country means that nobody, and in particular not the government, and worse even, legislation by the government, may coerce Muslims into marrying and divorcing under a law which is contrary to Islamic law. Neither can Muslims be constrained from marrying or divorcing under Islamic law or legislation codifying Muslim personal law. It is against this background that we analyze the Women's Legal Center Trust judgment. Firstly, I would like to explain what a Muslim marriage is. A Muslim marriage is a marriage concluded in accordance with Islamic law. There is an understanding that when two Muslim persons conclude a Muslim marriage and then register a civil marriage, the Muslim marriage is so recognized. UUCSA differs with this understanding. UUCSA is of the view that this is not what the Women's Legal Center Court said. UUCSA argues that a Muslim marriage is entered into when the parties marry each other in accordance with Islamic law. Parties who subsequently enter into and register a civil marriage will then have concluded two separate marriages. When two Muslim persons marry under a civil marriage, that is not an Islamic marriage. That is not a Muslim marriage, and that is not a marriage under the Sharia. The only marriage which can be described as a Muslim marriage is a marriage where two Muslims, a man and a woman, conclude a marriage under the law of the Sharia or Islamic law. Naturally, UUCSA concurs with the court's declaration that the Marriage Act and the Divorce Act are unconstitutional because they do not recognize Muslim marriages. However, UUCSA goes further than that, and UUCSA says that the failure of the government to provide legislation recognizing Muslim marriages and Muslim marriage and divorce law is additionally unconstitutional. In fact, UUCSA believes that the real unconstitutionality is the fact that there is no law provided by the government recognizing Muslim marriages. UUCSA believes that if there was a piece of legislation recognizing Muslim marriages and Muslim divorces, a codification of the law of Islam, then the court would not have declared the Marriage Act and the Divorce Act unconstitutional. So the real unconstitutionality is the absence of a law recognizing Muslim marriages. At least once a month, I get a call asking whether Muslim marriages are now recognized since this case. I can understand the confusion because there was a moment when many thought that because the Women's Legal Center won the case, therefore Muslim marriages are now recognized. This is not the case. Now, I have on a previous occasion provided a more comprehensive argument substantiating this view. However, for our purposes today, I will just read one paragraph from the judgment. The court says at paragraph 1.6, the declarations of invalidity are suspended to enable the President and Cabinet, together with Parliament, to remedy the foregoing defects by either amending existing legislation or initiating and passing new legislation in order to ensure the recognition of Muslim marriages as valid marriages for all purposes in South Africa, and to regulate the consequences arising from such recognition. This paragraph tells us that the court did not declare that Muslim marriages are now recognized. In fact, the court argues that that does not fall within its jurisdiction. It's a competency of Parliament. And therefore, the court made this judgment in this manner. And the court says that it gives government 24 months, and that 24 months expires in June 2024, just a few months from now, to bring about legislation which will recognize Muslim marriages and to regulate the consequences of such marriages. So after this declaration, the court provides certain remedies. There's remedies in terms of Section 172 of the Constitution. Section 172 of the Constitution requires that the court make an order that is just and equitable. Paragraph 1.6 requires that the government amend existing legislation or initiate and pass new legislation in order to ensure the recognition of Muslim marriages as valid marriages for all purposes and to regulate the consequences arising from such marriages. Remember that right in the beginning, in fact, in the first paragraph, the court said that a Muslim marriage is a marriage solemnized in accordance with Sharia law. This emphasizes the point that I made earlier. A Muslim marriage is a marriage solemnized in accordance with Sharia. Here the court says that the government must ensure the recognition of Muslim marriages. That means that the court has ordered that the government must ensure the recognition of marriages solemnized in accordance with Sharia law. The court continued and said that this legislation must perform another function. The legislation must also regulate the consequences arising from such marriages. These words of the Constitutional Court can only mean one thing, and that is that Muslims have a constitutional right, and now a Constitutional Court ordered right to have Islamic marriage law codified and Islamic divorce law codified. While we await the government passing the new law, the court put certain interim measures in place. The age restriction that apply to marriage through the Children's Act and the Recognition of Customary Marriages Act now apply to Muslim marriages as well. That means that children under the age of 18 years may not be given in marriage or engagement. There are a softening of this rule under the Recognition of Customary Marriages rules. I'm not going to go into all of that today. The court declared further that Muslim marriages may now be dissolved in accordance with the Divorce Act on the basis that all Muslim marriages shall be treated as out of community of property and that Section 7.3 shall apply irrespective of when the marriage was entered into. So the reason why I said that I'm not going to pay much attention to the Constitutional Court's case when it extended the application of Section 7.3 to marriages that took place after 1 November 1984 is because the court has already ordered a year before that, in this case, that Section 7.3 shall apply of the Divorce Act shall apply to Muslim marriages irrespective of when the marriage took place. So it is UUCSA's view that the application of the Divorce Act to a Muslim marriage is like trying to fit a square peg into a round hole. Firstly, Section 3 of the Divorce Act says that the court may dissolve the marriage. However, we know that a Muslim marriage may be dissolved by talaq and certain other measures, but not by a secular court. So even if a secular court terminates a marriage, but the marriage was not terminated under Islamic law, that marriage still persists. So this amalgamation by the court of a Muslim marriage and South Africa's secular law doesn't work, at least not in this instance, of Section 3 of the Divorce Act. However, let's go to Section 7, subsection 3 of the Divorce Act. And the section reads as follows. I will only read the relevant parts. And it reads as follows. A court granting a decree of divorce in respect of a marriage out of community of property may, subject to the provisions of subsection 4, subsection 5, and subsection 6, on application by one of the parties to that marriage, in the absence of any agreement between them regarding the division of their assets, order that such assets or such part of the assets or the other party as the court may deem just be transferred to the first mentioned party. An order under subsection 3 shall not be granted unless the court is satisfied that it is equitable and just by reason of the fact that the party in whose favor the order is granted contributed directly or indirectly to the maintenance or increase of the estate of the other party during the subsistence of the marriage, either by rendering services or the saving of expenses which would otherwise have been incurred or in any other manner. So essentially what this section says is that a court granting a decree of divorce in respect of a marriage out of community of property on application by one of the parties may order that certain assets of the respondent be transferred to the applicant in the court if the court is satisfied that the applicant contributed directly or indirectly to the maintenance or increase of the estate of the respondent, either by rendering services or by saving expenses, or in any other manner. In order to explain UUCSA's position on Section 7.3, I will use some scenarios. So, Section 7.3 of the Divorce Act permits a court to transfer assets of one party to the other party if the court finds it just and fair. This may only be ordered under the following conditions. The marriage must be out of community of property. The marriage must exclude the accrual system. The claimant, and in most cases the claimant will be the wife. So let's say the wife, the claimant, the wife, must have contributed directly or indirectly to the husband's estate during the marriage. The real issue that concerns many Muslims, I could say many Ulamaa, but I've even heard this concern from Muslim lawyers, so I'll just say Muslims, is that if at the entry into the marriage, the two parties agreed to keep their two estates separate, why then should a court be empowered to interfere with this agreement? Theoretically, this sounds logical. In addition, courts are not empowered to interfere with other types of contracts. Why then is it permitted to interfere with a marriage contract? The answer does not lie in looking at the terms of the contract. The answer lies in carefully analyzing the facts or the manner in which the parties conducted their daily lives. Often, the parties agree to keep their estates separate, but in their day-to-day lives, they mix their estates together. Let us look at two scenarios. Firstly, both parties work and earn an income. The husband buys the assets, the house and the car with his money, and the wife pays for the consumables, the food, the clothes. She also pays the salary of the maid. At the end of the marriage, the wife has nothing to show for her income because it is all consumed, and the husband is sitting pretty with his house and his car. In this case, it is argued, not yet by UUCSA, I'm coming to the part where UUCSA argues, but it is argued in general, that the husband benefited from the wife's income in that because she paid for the household consumables, he was able to build up a bigger estate. Had he paid for the consumables, his estate would have been much smaller, and that is how he benefited from the wife's income. Secondly, in a second scenario, the husband goes out to work and the wife stays at home and cares for the home and the children. All the assets and consumables are bought with the husband's income, and therefore the entire estate belongs to him. In this case, no consideration is given to the contribution that the wife makes and by caring for the home and the children. It is argued that her contribution may not have brought an income into the home, but it certainly saved money for the home and indeed made it easy for the husband to go out there knowing that his house is safe and his children are in the best hands possible. That, it is argued, cannot be worth absolutely nothing. In both these cases, it is clear that despite the parties agreeing to live separately or separate financial lives, in reality, their finances were fairly mixed up. Is it then fair for the husband in these two scenarios to rely on the entry agreement when the facts of their lives were not in line with the entry agreement? The agreement was based on separate monies, but their everyday life was based on mixed monies. A redistribution claim asks the court to look beyond the agreement and to look at how, in fact, the parties lived their lives. Such a claimant is asking the court to evaluate her contribution and to find whether there was value in it. If the court finds value in her contribution, it must see whether that value contributed to the husband's estate. If the answer to these two questions is positive, then the court must quantify her contribution in relation to the husband's estate and transfer that amount to her. So now we come to what UUCSA's position is on Section 7.3 of the Divorce Act and how it applies to Muslim marriages. Keeping in mind that a Muslim marriage is a marriage concluded by two Muslim persons under Islamic law. Initially it is difficult to precisely say what UUCSA's view will be on this issue because UUCSA has not taken a formal decision on this issue. And UUCSA has left it to its various constituents to decide on how to deal with this matter. However, I've consulted a number of ulama on this question, UUCSA members as well as other ulama, and their views can be summed up as follows. There are those who say that the Sharia does not allow for redistribution. Therefore, Section 7.3 cannot be imposed on Muslim marriages. In their view, the court has erred in imposing this on Muslims. They argue that Islamic law is one single system, and taking Section 7.3 from another legal system and imposing it onto the Sharia is wrong. The two systems do not go together. That is one view. And this is a real view. And it's a commonly held view. The second view is that in the case where the claimant made a direct contribution, like in our first scenario, in which the wife worked and earned an income, and her income was used in the house, a redistribution is possible. They say that all that the wife will be doing in this case is claiming what she actually contributed towards the household. They continue to say that they cannot support a claim in which the wife claims for indirect contributions, like performing household chores and tending to the children. They argue that quantifying this type of conduct into a monetary value is not permissible in Islam. These actions, they say, are not done for monetary value, but for spiritual value. They continue and say that the wife may be able to claim for indirect contributions if there was a specific agreement between the spouses laying this or regarding this matter of the wife's indirect contribution to the household. Now I will move over to the last group, the final group of ulama that I've consulted on this matter. And I want to emphasize that these consultations that I'm talking about have been taking place over more than almost 2 years now regarding this very issue. Since the Women's Legal Center judgment from the SCA from that time already. So the last group says that they support a wife's claim for direct contribution. So our first scenario in which the wife works and she makes an actual monetary contribution to the household, they support that. They have no problem with that, same as the second argument. So now, going over to a wife's claim for contribution or indirect contributions in which she made contributions by doing chores in the household and tending to the children and things like that. So they say that they will also support a claim for indirect contributions. They argue that the Sharia places a responsibility on the husband to provide for all the household necessities, including household chores, as well as tending to the children. This responsibility remains on the husband, irrespective of who actually does the work. Therefore, they say that if the wife performs this function, then she may claim for it in a redistribution application. They agree that if a wife can do this for spiritual benefit, or rather they agree that a wife can do this for spiritual benefit. However, the very fact that she institutes a claim means that she did it as a contribution towards the household. They add that in their experience, so many of the ulama that I consulted also deal with real life situations. And they say that in their experience, in most of these situations, there is a tacit agreement between the parties, between the spouses. And this tacit agreement cannot simply be dismissed. It must be recognized. Even if the marriage or the overarching agreement between the parties is that of out of community of property without the accrual, there is always a tacit agreement between the parties And this tacit agreement modifies the overarching agreement. And this tacit agreement is that Party A will perform certain functions and Party B will perform certain functions. And both this will be a contribution towards the household. And based on this third group of ulama supports a claim for direct contribution to the household and indirect contribution to the household. So in conclusion, it is the position of the United Ulama Council of South Africa that a proper interpretation of the Constitution provides a guarantee for Muslims to marry and divorce under Islamic law and to have that law legislated. This, UUCSA says, has been confirmed by the Women's Legal Center case. UUCSA is further of the view that the application of the Divorce Act to the termination of Muslim marriages, even as an interim measure, is the creation of a legal Frankenstein. The two don't go together. Finally, UUCSA may be able to work to make room for a redistribution application in its understanding, but as part of Islamic law. And this redistribution application will be not that the wife is claiming assets from the husband, but the wife is claiming her own assets, which is currently mixed up with that of the husband. So that is the understanding. Thank you, Sheikh Munir. Shukran, jazakallah khairan. That is where I conclude.
Okay, shukran, Mr. Ismail, for that presentation. We will now go into the Q&A, and for that part of the session, I hand over to one of the facilitators, Mr. Muhammad Hussein Sange.
I have a question here. Good afternoon and salam alaikum, everybody. I have a question here from one of the participants, if I may give the question, if that is okay.
Are you asking me?
Yes, I'm asking
sure.
you.
Yes,
okay,
sure.
so this is from a former student. Okay, let's just see what the question is. She has two questions. So what is the legal solution to this conundrum, taking into account the reality that we live in South Africa, where the Constitution of South Africa is the supreme law of the Republic, and all laws and conduct must be consistent with the Constitution? So that is the first question. And then how do we give effect?
Can I just respond to that part?
Okay.
So I don't know exactly what the questioner is asking. It's a very broad question, but let me respond in this manner. There are those people who are opposed to a codification of Islamic law as law to govern Muslim marriages. And the reason why they are opposed to it is because they are of the view that there are certain aspects of Islamic law which will be unconstitutional. Then there are those people who say that the Constitution does not only comprise of the equality clauses and the dignity clauses, it also comprises of Section 15, which provides the freedom to practice and live out your religion as you please. That's number one. Number two is, if there are two people, a couple, who wants to marry in accordance with Islamic law, pure Islamic law, both wife and husband, should they be denied that right? Will it be constitutionally correct to deny them that freedom to live out their life in a purely Islamic way in South Africa under the Constitution? the Constitution guarantees them that right. That is what I started this whole talk with. That is the reason why I would put that in, to show that the Constitution provides or guarantees the right that Muslims can live a purely Muslim life freely in South Africa. The problem comes in when one tries to impose his view on another. For instance, those people who want to live a purely Muslim life should not impose it on others who don't want to. And those who don't want to live a purely Muslim life, who don't want to live their life in accordance with the Sharia, should not impose it on those who want to. So, and this is how UUCSA has spoken to the government previously, because this process has gone on for many, many years, since 1994, in fact. So it's 30 years now. And I've been involved personally in this for a while now, writing myself to government on behalf of UUCSA on these matters. And our submissions are that marriage law, particularly for Muslims, I'm not speaking for other people, but for Muslims, must be written in such a way that it is flexible, sufficiently flexible for all Muslims to participate in. So those people who want to live a purely Muslim life and want to live their marriage and divorce life purely under Islamic law must have the freedom to do that. And South African law must recognize it, and it must be able to be practiced in South African courts, so that this law can have the force of the courts, unlike we are practicing today. And those people who don't want to live their marriage and divorce life purely under under Islamic law must also have the freedom and flexibility of marriage law in South Africa to do so. But and this is the reason I understand from government why we don't have Muslim law yet in South Africa, is because there are a number of clearly defined groups, each one pulling in opposite directions, and the government doesn't know what to give us. We must learn how to live together as Muslims. And we must learn how to develop a law, and it's not difficult. We must learn how to develop a law that is suitable to everybody.
I think I'll just going to give the second part of the question,
Yeah.
which I think you've already touched on, and then she's just got another part. She wishes to remain anonymous. She's a legal practitioner and a former student. How do we give effect to Sharia within a country where all laws and conduct is subject to the Constitution? And then we are genuinely concerned and not opposed or prejudiced. As legal practitioners, how do we balance the competing rights, and how can this be protected in a legal framework which will pass constitutional muster? Between us, we have to advise government on this, and it would be useful for some substantive legal solution. So that is where I will rest that, and then Mr. Mohammed Sange will take the rest of the questions.
Attorney Ismail Mohammed, I think there was a question posed to you.
Are you going to read the question for me? I don't see it on my screen.
No, the question was sent to me. The question was
Oh.
sent to me, so I don't think Mr. Sange has that question, and that is why I read it out before he would start his questions.
Okay, not a
So
problem,
I
Prof.
Yeah, I think maybe you have, I think it's a question that is not going to be answered in in the matter of time that we have. But maybe Mr. Sange can go on with the other questions, introduce himself and then go on with the questions in the chat.
Assalamualaikum warahmatullah to one and all. Shukran, Prof. Musa, for handing that over to me. From the chat box, I noticed there was just a general question from Mr. Sneem Ismail to ask where can we obtain the recording of this webinar for those who missed it. I will reach out to our ICS department and have the recording sent to everyone who registered and have this event available to everyone who is present and who wasn't able to avail themselves today. So I don't think there is any other questions. There is, however, a very in-depth comment there from Shaukat Ali, and we thank him for that. And he did inform us as well that he was unable to attend today's event, and he put forward his apologies.
Mohammed, Mr. Shaukat Ali is indeed has managed to join us, and he has a question here that he's put on the chat. So if you can see, just check the chat, you will see there's a question that he's posed.
Here's the question. Thank you so much, Prof, for that reminder. So I will proceed to read the question. The question is as follows. My problem with the issue of maintenance in the event of an out-of-community of property is that it is confined to the iddah period. And thereafter, in most instances, women have to enforce a maintenance claim in a maintenance court, which becomes very problematic. I don't think a redistribution agreement will help much. Attorney Ismail, would you like to comment on that perhaps?
I think Professor Najma Musa and Sheikh Shaukat Ali are the experts on this topic. So it's a bit unfair to ask me that question because they are the experts on this topic. But also the question doesn't pertain to our topic of today. A redistribution agreement is not about maintenance. However, a redistribution agreement, one of the factors that the judge takes into account is what maintenance orders are being made. And when maintenance orders are being made, the judge also takes into account what the redistribution order is being made. So that those are the only manner in which the two go together. I understand what Sheikh Shaukat's question is. However, I don't think it pertains to our topic of today.
Okay, thank you, Attorney Ismail, for that answer.
I would
think
Sheikh Shaukat wrote a master's thesis on this topic.
Yes.
So he can answer the question for us.
Noted. But unfortunately, we don't have ample time. Inshallah, in the next event, we will open up the floor and hopefully have more time so that we can discuss this and then hand over the mic as well to Advocate Shaukat Ali. We are really honored to have you in our presence here today. But on that note, I'd like to thank everyone for all the questions posed. And on behalf of the MPLU, the Muslim Personal Unit at UWC, we'd like to thank Attorney Ismail Mohammed for that brilliant insight into the position of UUCSA in relation to the Women's Legal Center judgment. I am surely positive that each and everyone in attendance today most definitely learned something new. And if there was any unclarity on the judgment in itself, which there certainly is, it was most certainly and most definitely clarified through your wise words today. And I would like to put forward a vote of thanks. Just looking at the chat box again, I see there are no other questions. And put forward a vote of thanks firstly to the speaker as mentioned already, Attorney Ismail Mohammed. Thank you so much for honoring our invitation, coming here today. You are our first, this is actually our inaugural event. And I think it was befitting to have an alumni of UWC started off for us. I think that carries quite a bit of weight. Above and beyond that, I would like to thank the UWC Law Faculty, in particular the Dean of the Faculty of Law, Prof. Jacques de Waal, for his assistance given to the Muslim Personal Unit thus far. I'd also like to convey our sincere thanks to the head of the Department of Private Law, Professor Sumari Falyoun, for her guidance given thus far. The head of CLEAR, the Center for Legal Integration in Africa, Professor Anthony Diala, who is in the audience today as well, for his guidance and assistance also given. And then I would be rather remiss, if I did not give thanks to our technical department, specifically located in the DOI, the Dalla Omar Institute, namely Ms. Kay Sapto, for assisting us in expediting the process in getting the word out about this event, especially on such short notice. And additionally, in concluding, also thanking everyone and all parties that assisted in making this event possible. I have to remind everyone that this is the event, the first event of the Muslim Personal Unit at UWC. And we will also be hosting many events to come, and we are hoping that we'll be honored to have Attorney Ismail Mohammed present for us and assist us in our endeavors going forward for many, many years to come. And after saying all that, in closing today's successful event, as I would label it, and I'm sure everyone will be in agreement with that, as per the prophetic sunnah, I would like to invite everyone to join me in reciting Surah Al-Asr, and thereafter concluding today's event. And once again, shukran to everyone for attending and for your valuable input. Bismillahir Rahmanir Rahim. Wal 'asri innal insana lafi khusr illa alladhina amanu wa 'amilus salihati wa tawasaw bil haqqi wa tawasaw bis sabr. Subhana rabbika rabbil 'izzati 'amma yasifun wa salamun 'alal mursalin walhamdulillahi rabbil alamin. Shukran to one and all, and I hope you have a lovely day further.